my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and California's Age Appropriate Design Act. People are calling it CAADCA, CADSA. Anyway, California's Age Appropriate Design Act is a riff off of the UK's Age Appropriate Design Code. This design code is very popular. It's been a guide to me and other companies that I consult with. Other regulators around the world have looked very closely at this. I think it's very telling that California thought well enough of this to be able to implement their own version of this. So the purpose behind the California Age Appropriate Design Act is to create more privacy by design in apps, anything that connected to or that children use. There are some big things in this law that people really need to know about. First of all, it was signed into law in September of 2022. It goes into full effect on July 1st of 2024. Even though that seems like a long way away, it actually isn't. There are some really big things in this act that are very important, not just to California, but because California is very influential, it's very possible that other states will pick this up. And it's also very possible that the companies will start to emulate some of the contours of this law. So 3 big things to know about this particular law. First of all, it raises the age of what they consider a child in the state of California to age 18. So the federal law, COPPA, which is around children online privacy, those rules are for children 13 and under. So it's a big deal that California kind of leaps over that and says a child is someone who's 18 and under. This has a big implication, especially because children between 13 and 18 have, they have money, they have jobs, they have credit cards, so I think, it's going to be difficult for companies to adjust to this. So it's good that they have a bit of time to look at that. Also, it creates a requirement for all companies to deal with children's data under the age of 18 to create a data protection impact assessment by July 1st, 2024. So all companies that kind of fit within the contours of like CCPA, CPRA will need to do this particular impact assessment. So they have to do one at least by then. And if a regulator in the state of California asks for it, a company has to turn it over within 5 days. That's kind of a big deal. We've not seen that yet in the US. And also, this particular law has fines between $2,500 and $7,500 per child, depending on the seriousness of the infraction. So this is game changing, I think. I think at a federal level, the child laws in the U.S. are probably some of our strongest federal legislation on children. But this particular act, even though it's just in California, I think it's going to have a huge impact on businesses all over the United States because, as I said, California is very influential. Businesses don't want to have different rules for different states, so they may actually adopt some of these things. And it's probably good best practice and good kind of data privacy hygiene for companies to know what their risks are in this area. So it remains to be seen how people take this. I'm hoping that people don't wait until July 1st, 2024 to try to get started on this. But the time is now. So companies that have data of people who are under the age of 18 in any state, you need to really be thinking about your risk in this area, not just from regulation, but from a business perspective. That's it. Thank you.